So the special court at the Rouse Avenue Court, the special judge has discharged all the accused in the liquor scam case, a case that changed the entire political scenario of the national capital region of Delhi. Your thoughts on that order?
According to me, this judgment is a defining moment in the criminal jurisprudence of this country. So what is happening is that you have some evidence which you claim to be against somebody, and you start the criminal case, and then you use the same evidence for the purpose of saying that I need to arrest him and you want to take him on remand, etc. Now, when you analyze the evidence, most of the evidence, or rather all of it, is inadmissible evidence. When I say inadmissible, means that evidence which is not, which will not stand in court. Now, if the evidence which will not stand in court is used to start the case, I don't say case cannot be started. It can be started, but it cannot result in arrest or giving remand of an accused on the basis of inadmissible evidence. You will recall the Jain Hawala case. Jain Hawala case was also like this when it started. The Chief Justice of India monitored this case, ultimately got it registered, got thrown out at the trial court, and nothing happened thereafter. Fortunately, in Jain Hawala, no arrests were made in spite of all this, because it was not admissible evidence. No arrest was made. But the sad part is that in this case, arrests were made, and higher courts, even Supreme Court, did not realize that these evidences are not admissible in law, and accordingly, as an under trial, you can't put somebody behind bars, because the moment you put somebody behind bars, you actually create a huge amount of damage to his reputation, damage to his life in many ways, because that period can never be given back to him under any circumstances. And in case he is running a political party, damage to the political party also. So I think the defining moment will be that henceforth, at least Superior Court for sure, if not even trial court, here the trial court has shown the courage. So I feel that trial court, High Court, Supreme Court should never accept the, or should always grant bail as an under trial, unless they have some evidence which is said to be admissible evidence. Starting a criminal case and prosecuting somebody can happen, but if there is no evidence to start with, then arresting that person and then also seeking his remand. Many a times remand is sought for extracting material from the accused. Now, our criminal jurisprudence, in fact our fundamental right, says that nobody can be compelled to depose against himself. Now you are asking somebody to depose against himself by taking him in custody. That's something which is completely illegal and unconstitutional. But that is what is happening day in, day out, and courts are also accepting these submissions to not grant bail, or to not grant anticipatory bail, or to also grant remand of the accused in such kind of cases. So I think this will definitely change the way criminal trials should be looked at in country. At least I feel it should change, because otherwise these prosecution agencies are being used as a tool for harassment, which is definitely not the intention of the criminal justice system. Even otherwise, in our criminal justice system, till you are actually proven guilty, you are deemed to be innocent. And here people suffer, with such inadmissible evidences, and this suffering can never be given back to them.
Sir, in law, is there anything that can be done against those erring officials who were working on the case? What exactly is it that can be done when an agency falters in this manner?
So fortunately, in this matter, even the trial judge has asked some departmental inquiry to be initiated against some of the CBI officers for having roped in some people in this case. I feel that the credibility of the CBI has gone down in this matter, and the credibility of whoever controls CBI is at stake. Because if the CBI, registers a case which didn't have any evidence to start with, obviously it can't bring in any evidence, and accordingly the trial judge has also, I believe, opined that you've done a very sloppy investigation. So it really shows that the criminal case was registered to start with for political vendetta, which the CBI should never be doing. So that's why I think this also will be the second thing which will have to be borne in mind for future cases. And that is not true only for CBI. Even the state police, we are seeing day in, day out, whichever party in power in the state is wanting to, start cases against, if it's a center versus state, then against the officers of the center. If it's the same this thing, then they are, targeting people of the other political party. And if the real inquiry happens against CBI officers, then in future they will also be circumspect before registering such cases.
So you've handled a lot of high-profile matters in which there are politicians involved or other people of repute are involved. Media plays a very important role in such trials.
This is one of those classic cases. In fact, starting from Jain Hawala, where it was more a media trial than actual trial, and media obviously cannot know what is admissible evidence and what is not. Media goes by the bulletins that the prosecution keeps issuing, and which is also very sad. Sometimes the bulletins are also based on completely misinformation or without any basis, and media goes completely gaga on whatever bulletins are issued by the prosecution. And because the media becomes so active in these kind of trials, that judges also start behaving as if they do something or give some indulgence to the accused in such matters, then they will be accused of harboring. So you require judges of caliber. You require judges who can sift the grain from the shaft, so that otherwise this kind of issues will always come again and again.